working now.
Ms. Welch?
Senator Nelson, we believe that if the committee finds that the FTC needs additional tools, that they should have them, and we would like to work with you in order to accomplish that. And we believe that any federal framework is obviously going to need enforcement tools, and so we support that.
Thank you, Senator Nelson. Senator Fisher?
Thank you, Mr. Chairman. I'd like to follow the ranking member's line of questioning a little bit here and maybe dig down into it a little bit more. We can't ignore the fact that we live in an economy that incentivizes the gathering of as much data as possible to either use it or to sell it. And as Congress is looking to strengthen the privacy, I think it's crucial that we prevent irresponsible data use. Mr. Tribble, do you think federal legislation is needed to protect consumers from some of the aggressive data practices? You talk about, more tools, but first you have to have legislation, and if you feel it's needed, what would you suggest?
Yes, we believe that comprehensive federal legislation is needed to help protect consumers. And, the reason for that is that, as Chairman Thune pointed out, there's a history of increased personal information flowing on the internet. I have oodles of information about my life sitting in my pocket right now. That wasn't true 5 or 10 years ago. That is only going to increase. So yes, we think that the comprehensive federal legislation is very important.
And you brought up your concern about how that might burden smaller businesses. So what do you think would be the best approach to federal legislation so we don't see that burden on smaller businesses where they have compliance issues and the costs associated with that?
Yeah, I think anything that can be done to help make things clear, make it so that businesses have one set of rules instead of many sets of rules to follow. And there may be other things. For example, we work with the Office of the National Coordinator for Health IT to come up with a model privacy notice for apps that use health information. And it's very helpful to us to be able to point our app developers, which we do, we link to the ONC site. These smaller companies may not have teams of lawyers to draft things, but that kind of thing can be very helpful, I think, to small and medium businesses.
And when we look at consumers' personal data, it can be used in reasonable ways and unreasonable ways. What's an unreasonable way? What's an example of that?
Well, personal data can be used in ways that are, first of all, unexpected or not appreciated by the person whose data it is. But specific ways, identity theft is an example of that. Simply information used out of context can be very misleading and affect someone's life. Information that is gathered on a person may be used to discriminate against them. So there are many ways that information can be used inappropriately. And once it's collected, it's often very hard to keep track of it. So sometimes those things happen.
Should companies focus on using data in ways that don't directly link to individual identity? For example, how can differential privacy advance efforts to reasonably minimize data collection? And can that be deployed at scale?
Well, at Apple, we're always challenging ourselves to see if we can provide a great service or product without collecting as much information. And there are actually an increasing number of tools to do that. One technique you mentioned is to disassociate the data from from an identifier. I think it's important to realize that there's no silver bullet here, because even information that has been disassociated from an explicit identifier, we've learned can be later, reassociated with that individual. Nonetheless, that action is helpful. With respect to things like differential privacy, those are some newer technologies that allow us to collect information about a group of people without collecting any single individual's information. For example, if I wanted to know the average amount of money a committee member had in their wallet, I could ask you, tell me how much money is in your wallet, but subtract or add a random number between, $100 and then tell to me. If I average those together, that's going to be, well, there's not enough committee members, but if there were thousands of you, it would be enough to tell me what your average amount of money in your wallet is without me getting the information about any particular individual. So those kinds of techniques, as well as using processing on the device or intelligence on the device to provide a service. For example, the iPhone will tell you where you park your car. We don't have to send where you parked your car back up to Apple. Your device can have enough intelligence to remember where you parked your car. So there are different ways you can implement the same service. Some are more privacy friendly.
Thank you.
Thank you, Senator Fisher. Senator Klobuchar.
Thank you very much, Mr. Chairman. Thank you for holding this important hearing. Thank you for all of you for appearing here today. I think you all know this comes at a critical moment when we are, for the first time, seriously looking at privacy legislation. Senator Kennedy and I have introduced the Bipartisan Social Media Privacy Protection and Consumer Rights Act, and that is due to what we've seen with privacy violations for people in this country. And the bill would make privacy disclosures more transparent, give consumers the right to control their own data by allowing people to opt out of having their data collected, and require companies to notify consumers of a privacy violation. In our legislation, the standards and enforcement are centralized at the FTC. So I guess I'd start with one simple question. Do you all believe that we need some kind of federal legislation to take place here so that we have some kind of privacy standard for consumers? Is there anyone that wants to? Mr. Cowie.
Yes, we've long supported comprehensive federal legislation. We do think it is important to protect consumers.
Okay. Anyone else
Yes,
disagree?
We too at Google support broad federal privacy legislation. We think it will benefit both consumers and the ecosystem of data-driven innovation.
Mr. Kiernan.
Like Google, we support both federal legislation.
Okay. Now, when Mr. Zuckerberg was here, I asked him about this idea of the 72-hour notification after a breach. Is there anyone that favors that? He said that it could make sense. No one favors that. Okay. I'm going to take that as a no. Okay. Then the other piece of the legislation makes for simple language, because so many of these privacy policies on your sites are very difficult to understand, and our bill requires that online platforms make plain language disclosures regarding how personal data will be collected and used. Do you think that would make sense to do something like that? Anyone?
Yes,
Mr. Enright.
In connection with our privacy policy, we actually take a great deal of pride in the fact that a cross-functional team of attorneys, technologists, and user experience designers are perpetually working on making our privacy disclosures as simple and accessible as possible, and we've received praise publicly for the work in that area.
Okay. Mr. Kiernan?
Like Google, we take pride in our privacy policy. In fact, this year we revised it completely. We started to consider how people would understand the basic information that they needed to have about the type of information we collect when we use it and when we share it. And what we actually did was we shared it with non-lawyers, non-policy people, and we asked them what issues they had in trying to understand it. We then went back, reconsidered those concerns, and then we worked in clever things like animations, graphics, pop-ups. We don't view that work as complete. We don't view it as static. The goal is to keep iterating on it and evolving to ensure that people do truly understand what we're doing with their data.
So speaking of static, our bill would actually also include a provision that a consumer could withdraw consent to the terms of service just as easily as they're able to give consent. Do you think that would be helpful, Mr. Kiernan, to include that?
Thank you, Senator. We already provide a variety of ways in which people who share information with us can opt out of sharing afterwards. We provide a set of tools from our privacy panel that allows people to determine what information they're sharing with us. So we do think it's an important component.
Okay. So do people have problems with an opting out idea? Oh, okay, good. I think I'll just use my last minute here on the honest, and there's obviously remedies. I'll ask those questions in writing under the bill. The Honest Ads Act, and I'll ask you about that, Mr. Enright. We've gotten support for that bill. This was, it's a bill I have with Senator Warner, and sadly, Senator McCain's no longer with us, but he was the lead Republican on the bill. And you know what it does? It says that for online political ads, there has to be disclosure and disclaimers, including for issue ads. Facebook and Twitter have both indicated that they support the bill, and Google has so far declined, and you are the biggest seller of online ads and expected to bring in roughly $40 billion in digital ad dollars in 2018. So could you talk about where you are on the bill and what you think needs to be done?
Certainly, Senator. To be clear, my area is privacy, so the issue of political ads is not squarely within my domain. That said, we appreciate your leadership on this issue. We do support the goals of your bill, and we look forward to working with your staff to move it forward.
Okay, and I do think that this has something to do with privacy because a lot of these political ads that have come from Russia and other places have interfered with people's privacy.
Certainly, I agree with you.
Photos of people that didn't consent to have them used. They falsified. The ads were obviously false, and they brought people to rallies and did all kinds of things that were false. And so I think you should think of it as not just sort of a thing over at the FEC, a political issue. It really goes to the fundamental misuse of the internet.
I agree with you, and I recognize that this is certainly relevant to the privacy conversation. It also, of course, involves other executives and teams at Google. But again, to reiterate what I've said, we do support the goals of your bill, and we're looking forward to working with your staff.
Thank you.
Thank you, Senator Klobuchar. Senator Moran.
Chairman Thune, thank you. I chair the subcommittee on consumer protection and data security of this committee, and I'm certainly committed to ensuring that consumers' personal data is collected, used, transferred, and stored responsibly with appropriate transparency provided by you in the industry. I do have concerns with the risks posed by the EU's general data protection regulations and the California Consumer Privacy Act. Those are concerns what it will mean to the internet ecosystem, especially the innovative entrepreneurial businesses that are positioned to be disadvantaged based upon these regulatory overhauls. And in some instances, these regulations conflict one with another. In the interest of protecting Americans from data misuse and establishing certainty for businesses so that we can continue to create jobs and innovate and compete in this global economy, I've been working with Senator Schatz, with Senator Wicker, and with Senator Blumenthal to collect the thoughts of all interested parties, including consumer advocates, industry representatives, academics, academicians, and to identify responsible federal privacy standards. And we most recently have sought for coordination with the Department of Commerce in a recent letter we sent to Secretary Ross last week. I appreciate your willingness to testify today, and I appreciate your perspectives. I've heard from parties who are concerned that the recently adopted California Consumer Privacy Act, which takes effect in 2020, could influence other states to enact their own versions of those regulations. This could lead to a patchwork of state privacy laws that internet companies engaging in interstate commerce would need to navigate in order to remain compliant. As some of you have mentioned, this is likely to have an unintended yet harmful impact on consumers due to confusion stemming from the uneven state-specific privacy requirements and choices. Additionally, entrepreneurial businesses with less resources than the companies represented at the table today would be unfairly precluded from engaging in the internet due to the complexity of regulations and compliance costs. A yes or no question for each of you: would your company support federal legislation to preempt inconsistent state privacy laws in the interest of providing clear privacy expectations for consumers and businesses?
Yes, Senator. In fact, federal legislation will be of very little help if it just becomes the 51st layering on top of 50 state rules. We need a comprehensive but singular privacy framework, and it should be a federal preemptive framework.
Thank you. You answer yes and no questions like I do. Thank you.
Thank you, Senator. Yes, as I mentioned in my opening remarks, we do have concerns about the California law, in particular, and the risk of a patchwork of uneven and disparate laws, I think, won't serve the core interest in protecting customers' privacy.
Thank you.
Yes, Senator, and I would point the committee back to our recently published legislative framework for privacy and data protection as one instructive point in this conversation.
Thank you.
Yes, Senator, we would support that. What I would also say is that Twitter's experience is we are actually quite a small company. We have only 3,300 approximately employees around the world. So we do tend to feel the burden of disproportionate regulation. So we think that it is important that there is a federal framework put in place to prohibit a patchwork of state-by-state laws.
Thank you.
I think it would be helpful to prohibit a patchwork, but I think it's very important from the standpoint of the consumer that the bar be high enough on the federal legislation to provide protection to the consumer that's effective.
Thank you.
Senator, we agree as well, and we believe that there needs to be a strong federal framework as well, and we think that consumers should be empowered with the ability to control their data through an opt-in.
Thank you. I support privacy rules that afford consumers the same protection no matter where they are in the internet ecosystem. Would you agree that regulating and enforcing privacy rules based upon the sensitivity of the data collected, used, transferred, and stored is the preferred approach and in the best interest of consumers in terms of certainty and transparency? Again, I think this can be a yes or no answer.
Yes.
Thank you.
Yes, Senator.
Thank you.
Yes, Senator.
Yes, Senator.
Yes.
Yes.
As a follow-up to that, and the Senator from Florida, the ranking member, talked about the FTC. Would you agree that the FTC is the appropriate federal agency to enforce any future federal privacy standards? Again, a yes or no?
Yes.
Yes, Senator. Yes, Senator.
Yes.
I think they have a role. I think effective enforcement is important, but I think there may be options on additional enforcement mechanisms, so I guess that's a qualified yes.
Thank you.
Yes.
Mr. Enright, I had a question for you in particular. I've run out of time, but I'll be back talking to you, I hope, if we have an additional round on data portability in your testimony. Thank you very much.
Thank you, Senator Moran. Senator Schatz.
Thank you, Mr. Chairman. Thank you all for being here. We're here at least partly because a lot of you are worried very much about just GDPR and also the California law. So let's lay that out. And you want something that you can work with so you don't have to navigate 50 different statutory frameworks. I understand that. And I think there's an opportunity to do something meaningful, but as Mr. Tribble said, we should make sure that we do something meaningful. And I understand that from the standpoint of some of these companies, the holy grail is preemption. And I want you to understand that you're only going to get there if this is meaningfully done. You're only going to get there. We're not going to get 60 votes for anything and replace a progressive California law, however flawed you may think it is, with a non-progressive federal law. So the first question I have, and it is yes or no, is do you think companies ought to take reasonable steps to prevent unwanted disclosures of that of data, and that companies should not use data to the detriment of their customers? Mr. Calley, and please yes or no.
Yes.
Yes, Senator, absolutely. Yes, Senator, consistent with the principles we just published.
Yes, Senator.
Yes, Senator.
Yes, Senator Schatz.
Thank you. I want to dig into the questions that Senator Nelson and others have asked about the FTC's authority. I think it matters very much if we're going to write a new federal privacy law that the FTC has rulemaking authority under APA. And I think it's a little bit of a sleight of hand this may just be an opener, but some of these companies are saying, we want a new federal law, we want to preempt the states from acting, but we don't really want to give the FTC the authority to make new rules in this space. The kinds of laws that stand the test of time are the kinds of laws that articulate broad principles and then empower the expert agency to flesh that out over time. And so do you support rulemaking authority in this new federal privacy statute?
So, Senator, I agree with your earlier statement. We expect a comprehensive federal law to be robust. As I earlier mentioned, we are always worried about unfettered discretion in an agency.
I'll just remind you, it's a yes or no. And
Yeah. So the point is,
I'll take that as a no.
no, it's not a no. And that's what I want you to know. We're not here digging lines in the sand.
I'll take that as a maybe.
A qualified yes?
I'll take it as a qualified, even better than maybe. Go ahead.
Thank you, Senator. For us, the answer is a qualified yes. The details matter tremendously. Innovation is critically important. Customer trust is critically important, and we'd like to be able to achieve those things in any.
Fair enough. I'll start taking qualified yeses. Go ahead.
Also a qualified yes. I think this is one consideration that has important points of interplay with other aspects of a comprehensive bill.
Qualified yes as well, Senator.
Come on, Apple, just give me a yes.
Well, effective enforcement is critical, but qualified yes as to the exact mechanism.
Qualified yes as well.
I just want to sort of articulate for the broader public, the problem right now is that if there's a violation, the FTC may or may not have a rule specifically that's being violated, and so the only thing that you can do is go to the company and say, we're notifying you that you're violating Section 5, and therefore let's enter into a consent decree, and then only if you violate that consent decree is there the authority to fine. And so there's no real economic consequence right now for violating existing rules or statutes as they relate to privacy, which is why we need the APA authority in any law. And here comes the second question. It seems to me absurd that we have to have the FTC come to a company and say you're violating something, then you come to an agreement, and then only if you're violating that do we get to fine. Because then it becomes just the cost of doing business to, as it were, move fast and break things. And so the question is, do you think the FTC should have the authority to fine in the first instance? I may get some qualified no's, which is fine.
Yeah, a qualified no.
I would say, subject to my prior qualified yes, it's not something that should necessarily be ruled out. Amplifying what has been said, I would also point out that many FTC consent agreements actually do include a civil penalty as part of the settlement. So the FTC has levied financial sanctions in the first instance.
Right, but they're mutually agreed to. You can't just levy the fine. It has to be part of the agreement.
Senator, we do think that there is room for measures for accountability. By way of example, we could draw inspiration from things that are in the California legislation or even the GDPR, tying penalties to a breach notification requirement. So there's room to discuss it, but it's a qualified yes, again, depending on the regulation.
Thank you.
We would consider that and would be happy to be involved in the discussions.
We believe if there are rules, they need to be enforced, but again, it's a qualified yes. We just need to see the full framework.
Thank you. Thank you, Mr. Chairman.
Senator Schatz? Lots of qualified yeses and qualified nos. That make them maybes. I think next up is Senator Tester.
Thank you, Mr. Chairman. I want to thank you all for being here today. By your testimony, I think that you guys believe that privacy is important. And what's kind of interesting as I hear the conversation come on is that you're asking for some level of regulation that you can depend upon, which I think is good. I guess the question is, are you doing everything you can do now to make sure that the private information is protected? And if you're not, why aren't you? Why? The question becomes is, I guess it's in the eye of the beholder, what is private information and what's not. But the question is why aren't the companies doing it off the chute? Why are we looking to Congress to pass laws to make sure that information is kept private? Is it because everybody wants the same playing field, or why is that? Can anybody answer that?
Senator, I think we are doing all we can as a company.
Okay.
I think there have been a lot of
So-
things that have happened this year, and I think the clarity of a federal
Okay.
law laying out a level playing field for all participants makes sense.
Good. So do any of you sell information that you get? I mean, I deal with most, if not all of the companies that are sitting at this table. Do any of you sell any of the information? No? Yes, no? Yes or no?
And we do not share information without affirmative customer consent.
Okay, do you sell it? If you get affirmative customer
With
consent?
affirmative customer consent, we may.
Okay.
As I said in my opening remarks, Senator, we're not in the business of selling personal information.
So that means you don't.
We run a number of services that are information dependent. So there's complexity in the answer, but there is a simple answer, which I believe is quite clear, which is
So-
we're not in the business of selling
All
personal.
right, so I'm a regular guy. I'm a farmer, okay? I'm not a technology person. This thing sometimes mystifies me, okay? And I'll get on and look for a set of tires for, say, my semi-truck. And presto changeo, I might be checking scores on ESPN or weather, on some other weather channel. And up comes an advertisement for tires for my truck. How the hell did they get that information? Can anybody tell me?
Senator, first responding to your initial question, we do not sell personal information.
Okay.
As I said.
So
in my
tell me how they get that information then. Because oftentimes I do that search on Google.
Certainly. And so what you are describing is that we offer an advertising platform where we provide publishers the opportunity to monetize their content via placing advertisements that may be targeted to a user's interests, subject to that user's privacy settings if they have not opted out of behavioral advertising. In that situation, no personal information is passing from Google to that third party. So we do not sell it nor share it in that context.
I assume that Catherine Cortez Masto doesn't get that advertisement when she gets on the Weather Channel. So what do you classify as being personal information?
Google classifies personal information as information that would be identifiable to an individual user. So your name, your email account, or other information that's tied to you or your device.
So maybe it's semantics, maybe it's something else. How do they know that that's the website? How do they know that this is the thing that they need to advertise the tires on when not everybody asks for tires on this piece of equipment? I guess what I'm getting to is that if you're not selling information, private information, but yet you're selling information that you don't deem as private, but I do. And by the way, tires are no big deal. I don't really give a damn. It's just an example. But there may be something else. Like, for example, if, say, a Russian firm were to ask for that information, or a Chinese firm. Have any of you been asked for information from a firm that does business in other countries, and you've either given it to them or sold it to them? Private or not? Any response to that? No response to that? No? Yes or no, or just don't know?
We don't sell personal information, Senator, and we don't sell it to foreign entities either.
Okay. Same thing with everybody?
Same for Apple.
Okay.
The same answer, Senator. And coming back to your previous question,
Yeah.
I want to be very clear. We understand the complexity of the internet ecosystem.
I don't.
And we understand that can be intimidating
Okay.
for our users.
For example, you're going to have to teach me how I can say no information is transferred for me, because I've never seen it. And if it has, it's been in print in so damn fine of print that I don't have time to read it all. So where would that exist, for example? I don't want to pick on you. I can pick on Amazon too, because we use you once in a while. Where I use Apple too, so I use you all. So where would I find the information?
Well, Senator,
to be able to say, you can't share this information with anybody, I don't care.
I'm quite happy to respond to this question because we take a great deal of pride in the investments that we've made in making this as simple as possible.
I like
in
that.
your Google account.
Okay, so tell me how to do it, because I get on Google every day.
You can jump onto Google and search for Google account. There will be a very clear indication as to how to get to those settings. And we try to make it as easy as possible. We're also investing very heavily, leading industry, in tools like your privacy checkup and your security checkup, where we invite people into that experience so that they can optimize their settings in a way that makes sense to them.
Okay, I would, and I think that's good. I don't know how heavily that you push that information out, because I'm somebody who values my privacy, as I think most people in Montana, and probably most people in this room do. And if I could say this website doesn't go anywhere else besides to my house, the information off it, I would do it every damn time. But I've never, ever seen that option, to be honest with you. Maybe I'm just not paying attention. Thank you all very much. Thank you, Mr. Chairman, for your flexibility.
Thank you, Senator Tester. As a follow-up to that, but is Google taking any specific steps to ensure that app developers don't improperly transfer Gmail user data to third parties?
Yes, thank you, Senator. I appreciate the opportunity to address this because they know there has been some confusing reporting on this issue specifically. I want to make it very clear that Google does not grant third parties access to users' Gmail data. We do, however, under certain circumstances, subject to users' settings and controls, allow the user to enable third-party app developers to have access to that data. One example of this would be for a trip planning application. A user can choose, after seeing a robust privacy notice from that third-party app developer, to decide to grant that app developer access to their Gmail to allow them to identify messages for things like hotel or flight reservations because the user sees utility in that. But we make that ability available to a user. However, we have strong policies in place around all of this, and if third parties abuse those policies, we will remove them from the platform.
Thank you. Senator Cortez Masto.
Thank you. Let me follow up on Senator Tester's, because I think this was an important part of the conversation. As we craft, or we look to craft a federal regulation comprehensive, you think it's important we identify what personal information is, because everybody might identify it differently. Is that correct? Would you agree, or do you all agree that you all identify PII in the same way? Let's start. I'm sorry, Mr. Chairman. We'll just go down the panel.
Yes, the definition of personal information would be appropriate.
Okay.
Yes, Senator, I think it's critically important, and it goes to the very core of protecting the most sensitive information while still enabling innovation to delight customers with great products and services.
Right.
Agreed, Senator. Clarity and consistency in definitions would be very helpful in protecting consumers and promoting compliance.
Agreed. I would also add that we think it would be very important in terms of the interoperability with regional frameworks around the world, that we have clarity in the United States as to the definition.
Yeah.
Yes, clarity is very important in that definition.
Senator, not only is clarity important, but with the way that we would approach it is that we would say there shouldn't be a differentiation between sensitive and non-sensitive. It gets really hard to draw those lines, and it may differ for Senator Tester versus you versus another person. And so that's one way to root out some of the confusion that I think consumers are feeling.
Yeah, I agree. The other thing that I noticed, and I think it was Mr. Kelly, you said this, was that the user's expectation of privacy is based on their using experience. I think you said something similar to that, and I agree. And I think for that reason, what we are trying to do here, on why we haven't been able to do it yet, is it's a very difficult thing to try to put one kind of template over this idea of privacy. But one thing I do support, and I'm curious, and this may have been asked, I had to step out of the room, a default opt-in. How do you feel about that? Yes or no? Would you support a default opt-in? And let's go down the panel again.
No, I don't support a default opt-in because I think it restricts the use of non-sensitive data that would restrict the benefits to consumers of data use. I do support an opt-in for personally identifiable information that is sensitive. And where we draw that line is a question, and it can be struck in any number of places.
Okay, thank you.
Your Honor, we think it's critically important to have clarity and simplicity with regard to the way our products and services work. We know that customers like services that are innovative, that work fantastically and give them what they want. And we're endeavor in every case to make it clear to customers if their data is being used, how it's being used, and actually to give them concrete benefits. An example would be product recommendations as you search on the website for a particular product. I do think that there's a concern that if you overlay a regulatory imperative like that on every interaction, you really risk breaking that kind of innovation, the innovative products and services that we know customers love.
Okay.
Echoing what was said previously, while we recognize that the most important thing in building consumer trust is preserving these notions of choice, transparency, and control, in everything that we build and in every product and service that we launch. We also recognize that when a user is engaging with an incredibly diverse portfolio of products and services online, much of the individual data processing is expected in connection with the normal delivery of the service that the consumer is engaging with. So if you had individual opt-in requirements for every processing operation, you could really impair the usability of the services and disincentivize users from engaging. So we think a balanced approach is appropriate.
And the rest of you feel the same way?
No, Senator, we have a different opinion about this. We believe that a default opt-in is the right approach, that this is the best way to empower consumers and increase their confidence. And we think that that's really good for business. If consumers believe in the services that they're participating with, that they believe their data will be protected, we think that they'll participate more. And so that's the position.
Okay.
Chart.
Anyone else have a different position, please?
I'll just point out, I mean, opt-in, we think is very appropriate in many circumstances, but maybe not all. One thing I've noticed since the GDPR came into effect, as I browse the web, every time I turn around, I'm getting asked to approve cookies. And so I think there's some risk of going overboard here, and the consumer will just be, their eyes will glaze over and they'll just click on it. So I think that's an important consideration.
Okay.
If I could just echo Mr. Enright's sentiments, I think it's very important to think about a practical example. If a person comes to Twitter for the first time, we want to be able to serve them in their relevant language. We do that based on their IP address. If we had to provide opt-in consent for that, it would be very difficult and challenging. We do, however, provide that person the ability to go back and change their location if they choose. So that's giving them meaningful control. But as a practical matter, a default opt-in would produce difficulties.
Thank you. And I know my time is running out, and I'll submit my questions for the record, but I do think the other thing that we need to figure out here is this idea of federal preemption and the state's role in this space, as well as the attorneys general as part of it. So thank you.
Senator Cortez Masto, Senator Lee.
Thank you very much, Mr. Chairman. Thanks to all of you for being here. Mr. Enright, can you tell me about how much Google spent in order to comply with the GDPR? Push your button if you could.
Thank you. Senator, I don't have a specific figure available. I can tell you that for multiple years in advance of the effective date of the regulation, a massive cross-functional effort was mobilized across the company, including significant capital expenditures and drawing time and attention of engineering and other staff towards building an appropriate compliance regime where they may have otherwise been working on products and features that users would be enjoying today.
Okay, sure. And I understand it can be difficult to present an accurate estimate, but I assume from your answer, we can assume that it was more than hundreds of dollars. It was more than thousands or tens or hundreds of thousands. I assume it was certainly into the millions.
It was orders of magnitude higher than any figure that you've mentioned, sir.
Okay, orders of magnitude higher than any figure I've mentioned. And offhand, any idea on how many human hours it might have taken for Google's workforce to bring the company into compliance with the GDPR?
We do have some analysis of that I would be happy to share with your staff, sir. I don't have those numbers available with me today.
Would you estimate that it was in the thousands of hours?
I would estimate that it was in the hundreds of years of human time.
Hundreds of years of human time.
Correct.
Okay, that is very significant and something that I think we ought to look to when we look at U.S. policy. Given all the resources that it takes for a company to do that, those are resources that can't go somewhere else. Doesn't mean that all regulations are bad. It does mean that those are things we ought to take into account whenever we increase the size of the federal regulatory footprint or the regulatory footprint of the states. Things get significant. They end up costing consumers more money one way or another. Federal regulations cost the American economy about $300 billion a year 20 years ago. Today, that figure stands at about $2 trillion a year just for federal regulations. Mr. Kelly, wanted to talk to you about an issue related to preemption. We have a lot of discussion going on whether, to what extent, Congress should preempt the playing field in this area. Preemption necessarily turns on the scope of federal power. As you know, the power of Congress is not limitless. We are said to be a government of limited enumerated powers, and one of those powers, the power I think probably most appropriate here, involves the power to regulate trade or commerce between the states with foreign nations and with the Indian tribes. One could argue that states ought to be able to regulate in this area individually. One could also argue that because the internet itself is a channel or instrumentality of interstate commerce, it is itself subject to Congress's plenary regulatory authority, much in the same way that our interstate airways are subject to plenary regulatory authority, exclusive regulatory authority. For instance, because we have interstate airways that are, by their very nature, channels of interstate commerce, even if you happen to take a flight between two cities of the same state, you're still subject to federal regulation on that front. How would you describe the authority in this area for Congress to act? Is it exclusive? Is it necessarily exclusive? Is it potentially exclusive or non-exclusive?
I think it's exclusive, Senator, and it's certainly good policy to treat it that way and approach it in that direction. Always important to respect state authority. The problem is data moves at the speed of light and it doesn't respect state boundaries. And the discussion here today shows we could strike the balance in any number of ways in a given law. And the problem you have is if California strikes the balance one way and New York strikes it another way and a third state strikes it another way, industry will be forced because of the fragmentation to comply with the most restrictive aspects of each state's law. And then we'll end up as a practical matter with a framework that is more restrictive than any state intended and actually produces less consumer welfare than any state expected. A federal privacy law here, because of the nature of the internet and the nature of these phones, which travel across state lines as you talk on them, it is an interstate service and therefore should be regulated by Congress.
Okay, so you're saying that perhaps even more so than with respect to aviation, this is the kind of thing that by its very nature could be pragmatically difficult to impossible to administer on a state-by-state basis. In theory, you could come up with a regulatory regime that could allow someone to take off in Northern Virginia and land in Richmond, Virginia. But it's much more difficult to contemplate something that would work as a practical matter with the internet.
That's correct. Given the nature of the data services, the internet, and the mobility associated with it, I think it's it's an area for federal regulation. There may be areas where we need to make sure we're not intruding on state consumer protection rules, but in terms of regulating privacy for data services, I think it's essential to be done federally.
Thank you. I see my time's expired. Thank you, Mr. Chairman.
Thank you, Senator Lee. Senator Peters.
Thank you, Mr. Chairman, and thank you to all of our witnesses for lending your expertise to us today. I think there's no question that consumers want better transparency and control over their personal information, which is why we're here today. And I hope that we leave today with a better understanding of what a federal privacy law might look like and how we protect consumer privacy while also making sure we're not stifling innovation in the process as well to allow this innovation to continue to grow because of all of the benefits associated with it. Well, my first question is for Mr. Enright. Through Google's dashboard, which is reachable through your privacy checkup feature, you provide numerous mechanisms for users to control the collection of their data. But I'm curious about what you know about the dashboard's effectiveness, and if you could share that with the committee. What percentage of your users actually utilize the dashboard?
Thank you, Senator, for the question. As I had said, my account, which is evolution of the Google dashboard that you reference, is an area where we are continuing to make substantial investments to ensure that we are providing the most robust set of controls to our users that we can, advancing those goals of choice, transparency, and control. We've also, I will point out, used tools like the Privacy and Security Checkup to actually proactively use some of the most expensive real estate on the internet on our Google homepage to invite users to interact with these privacy settings. We're not hiding them, we're not obfuscating them, we are actively promoting them because we actively want users to engage with them.
So how many are using it?
I do not have specific facts and figures around numbers or percentages of users that are engaging with their privacy settings, but I could certainly produce them for your staff.
Well, we'd love to follow up with you on that, because I think it's important to see how effective that is and how many folks actually realize that it's there or are able to interact with it. Because I know a primary concern of consumers is also how they're being tracked when they don't know it, such as when they're reading something on the internet or how much time they're spending on various websites that they may be on. Does Google's dashboard disclose information to your users about how you're tracking them across the internet?
The Google dashboard provides as much information as we are presently able about a user's use of our various products and services. When you say track users across the internet, what I am inferring is, can a user engage through My Google to see information about ads they've seen or related information, ads they've seen as they've traversed the internet? And yes, in fact, they can see a very robust reporting about their interaction with advertising across the internet as it relates to Google's own ads using My Google. They can also, I want to be perfectly clear, opt out of targeted advertising altogether. If a user does not want to participate in targeted advertising, we offer a very simple control where they can turn it off with a single click.
So my question is to the panel, well, first for you, Mr. Enright, but to the panel, would you support a federal privacy law that mandates disclosure of that type of tracking?
Yes, Senator, we would be very supportive of legislative measures that continue to promote increased obligations for transparency and, in an associated way, data portability, which we think is equally important.
Any other panelists like to comment if they'd support it? I assume everybody would support it if you're quiet.
We would echo those sentiments.
Everybody else would support that? Thank you. This would also be to the panel, and anyone can start with the answer. What do you believe should be the contours of personally identifiable information? How should it be defined in federal legislation? And how can we ensure that it will be adaptable to future advances in technology that could create new data points that would result in exposure to individuals, and think facial recognition and other types of advancements that would see? If anybody in the panel would like to comment about how we should deal with that, I'd appreciate it. Mr. Enright, I'll start with you.
Certainly. Thank you, Senator. As to your first question, an appropriate definition for personally identifiable information, as I had said in my earlier testimony, we at Google believe that there is a logical definition for personally identifiable information, which is data that directly identifies an individual user. Examples of this would be your name or your email address. I will point, as a point of reference, to the GDPR's definition of personal information, which also extends to information collected from a user. And we would say that in certain circumstances, that definition is overly broad. So for purposes of the legislative work of this committee, I would encourage that at least we use as a starting point the logical definition that one, I think a reasonable consumer would infer from the phrase personally identifiable information, which would be data elements that specifically identify an individual user.
Thank you, Mr. Chairman. I know I'm out of time, but I'd hope to get answers from other panelists at a future time if possible. Thank you.
Thank you, Senator Peters. Senator Hassan.
Thank you, Mr. Chair, and thanks to you and the ranking member for having this hearing today, and thank you to all of our witnesses for being here today. Mr. Enright, in your testimony, you described transparency, user control, portability, and security as Google's main privacy values. I am disturbed, though, by reports that Google is currently working on a search engine for China that would conform with the rigid censorship requirements of the Chinese regime. What's even more troubling is that the search engine would apparently link user searches to their personal phone numbers, both making it easier for the Chinese government to track and monitor its citizens and to develop their so-called social credit scores, where citizens can be denied any number of things from travel to access to school. 14 leading human rights organizations have called on your company to cease its work on this search engine, and a number of our colleagues, both Democrats and Republicans, have called on Google to provide additional answers to Congress, yet the company has yet to provide those answers. How will Google square its stated privacy values with this flawed Chinese search engine and the very real possibility that it may be used to repress human rights?
Thank you for the question, Senator. First, I would like to say that I take pride in Google's record on human rights. I stand by our long and track record in living by our values and launching products and services that reflect and are consistent with those values. With that said, I am aware of the reporting that you reference. And I will say that my understanding is that we are not, in fact, close to launching a search product in China. And whether we would or could at some point in the future remains unclear. If we were, in fact, to finalize a plan to launch a search product in China, my team would be actively engaged. Our privacy and security controls would be followed, and any such project or product would follow and be consistent with our values around privacy and data protection as I've described them here today.
So where do you think these reports are coming from?
I wouldn't speculate, Senator.
Okay, I would look forward to continued dialogue, and I think it would be in Google's interest to respond to the inquiries from members of Congress about what kind of work you're doing with China and whether you are even contemplating building a tool that could be used by a totalitarian regime to repress human rights. I'd like to move on now with a question again to Mr. Enright and to Mr. Karen. This is a really interesting panel because we have big businesses from internet service providers to online platforms to device manufacturers and retailers all here. I hope very much that Chairman Thune and Ranking Member Nelson will host another hearing on this topic where we can also hear from consumer and public interest groups to learn even more. One issue that I raised with Mark Zuckerberg of Facebook when he testified before this committee is that when your company's business models rely on maximizing the amount of time people spend on your products and monetizing people's data, it's simply not possible for us to trust that your companies will make the changes needed to protect America's well-being and privacy. Mr. Zuckerberg committed to working with Congress to develop ways of protecting consumer and constituent privacy and well-being, even if that results in some laws that will require adjustments to your business models. Will Google and Twitter make the same commitments here today?
Senator, we remain committed to working with this committee and with Congress more generally, as well as more broadly with legislators, regulators, and policymakers to ensure that appropriate privacy protections and data protection protections continue to exist and continue to evolve and iterate to address new and changing threats that come to face our services and our users. We believe that trust is absolutely paramount to the long-term success of our business, and it's the right thing to do.
Well, thank you for that. I want to hear from Mr. Kieran.
Thank you for the question, Senator. I would echo what Mr. Enright said, and I would add that at Twitter, the primary goals or objectives at the company at the moment are health and data protection and privacy. We take those very seriously. Everybody touches upon those concerns at the company. We believe they're not only key to keeping the people's trust who use our services, but also showing good responsibility with respect to where our place is in the world. We welcome the opportunity to work with you and your staff and the committee on those initiatives.
Well, I appreciate those answers, but I do have to tell you, and I'll look forward to following up with further questions, there is a basic disconnect here. You can be as well intended as possible, but if your business model drives a particular set of behaviors and the monetizing of people's data, for instance, and keeping them online, and your business model and your responsibility to your shareholders is one thing, and the needs of the public and consumers is another thing, it may behoove you to work with us to come up with a regulatory scheme, as Mr. Zuckerberg committed to do, that removes some of that conflict. Because at the end of the day, if your business model is driving you in one direction, all your good intentions may not help consumers who really are demanding it. Thank you for letting me go over, Mr. Chair.
Thank you, Senator House and Senator Wicker.
Thank you very much. This late in the hearing, let's see if we can sort of summarize and make sure where we are with regard to the positions of all the companies you represent. There is a fundamental principle that any federal privacy legislation should include preemption of state data privacy laws. Do each and every one of your companies agree that our federal legislation should include preemption? Mr. Calley, and we'll go down there.
Yes, they do.
Mr. DeVore?
Another qualified yes, Senator. The details matter a lot. I do think it's essential to avoid the risks that we've identified, which is a patchwork of state laws that have the risk of imposing regulations that don't actually serve the core interest that I think we're all focused on today, which is ensuring that customers trust the ways in which their data is being
Qualified, yes. Mr. Enright?
Yes, Senator, we support a uniform rule of law across the country.
Mr. Kiernan?
Yes, Senator, but I'd add, for Twitter, it's not the primary reason that we're here. We do believe this law needs to balance the protection of individuals' rights with the freedom to innovate, so preemption is a part of that, but it's not the
Oh, sure. Yeah, I'm going to ask about other things too. Mr. Tribble?
As I said before, yes, assuming that it meets the bar of protecting consumers meaningfully.
And Ms. Welch? Okay. And do we all agree that the FTC is the place for primary enforcement of this? Mr. Calley and on down the line.
Yes.
Yes, Senator.
Yes, Senator.
Yes, Senator.
Yes.
Yes.
Okay. So let's talk about this this issue where we might not be quite so uniform. And so let me direct this to Mr. DeVore, Mr. Enright, and Mr. Kiernan, whose companies are members of the Internet Association. The Internet Association, on the issue of technology and sector neutrality, has called for federal privacy legislation that is indeed technology neutral and sector neutral, and that the legislation should include protections that are consistent for individuals across products and services and apply to online and offline companies alike. So, Mr. DeVore, Mr. Enright, and Mr. Kiernan, we'll begin with Mr. DeVore. Your companies are members of the Internet Association. Does that mean that your company believes that edge providers and ISPs and all other online entities should be subject to the same privacy requirements?
Thank you, Senator. Yes, and again, we believe the core principles here should apply to everyone, and that's simplicity, that customers understand how their data is being used, that it's used responsibly, consistent with their expectations, and that they have ultimate control.
And Mr. Enright?
Yes, Senator, I would refer back to the legislative framework that was recently published and the general principles of choice, transparency, and control, which all, I think, reflect an understanding that a uniform application of law, a harms-based approach across industries enforced by the FTC is the right way to go.
Mr. Kiernan?
We would echo both of those sentiments.
Okay, so now let me turn to Mr. Calley and Ms. Welch. Do you think a national privacy law should take an online entity's business model into account, or should all online entities be subject to the same data protection requirements? In other words, do you differ at all with the previous three witnesses? Mr. Calley?
Senator, the information that a consumer gives to a company is sensitive or it's not sensitive without regard to what the company's particular business model is. And the fact that we today see business models that we think are different, a business model that is a free model online because it's fully ad supported versus a model that's fully supported by the subscriber, that doesn't really describe reality. Increasingly, you're seeing hybrid models where you have a mix of subscriber payments, but they're discounted because there's also ad support. So the distinction between the models also fades. So just to repeat, from a consumer perspective, it's all the same information and it's sensitive or not. And then from a model perspective, we have a mix of models in the market.
Oh, okay, well, can I get a yes or no? Do you agree with the Internet Association's position with regard to this issue?
I agree that it should be, yes, I do, consistent.
Okay. And Ms. Welch, you have the last word.
Yes.
Okay. And my time just expired. Thank you very much.
Thank you, Senator Wicker. Senator Blumenthal.
Thanks, Mr. Chairman. I want to thank the chairman for having this hearing and also thank him for mentioning a potential second hearing involving the European Union GDPR officials, an advocate from California, and public interest groups. I think that public interest groups particularly play an extremely important part in this conversation. They were successful in California and in Europe, and I want to also express my appreciation for all of you for being forthcoming in meetings with me and my staff, as well as your being here today, not to mention your tremendous contribution to our economy, to quality of life, to so many aspects of American consumers. Let me just sort of establish some first principles. Does anyone here believe that Americans deserve less privacy than Europeans? If you do, raise your hand. The record will reflect no hands were raised. Do any of you believe that all Americans deserve less privacy than Californians will have under the new law going into effect there? Again, no hands raised. So many of you have been critical of the GDPR, and some of you, let me be very blunt, fought the California law. That's a matter of public record. I am really seeking assurance that you will put your money where your mouth is. And I recognize that we are talking here about monetizing an asset, which is consumer information. Your companies have lots of it, and they are a principal means of profit making. And I guess my first question, or my next question for you is, do all of you agree that Congress cannot settle for voluntary practices or self-regulation? Do all of you agree that we need mandatory practices and rules of the road when it comes to privacy? Again, no apparent dissent from that point of view. Because voluntary rules have just proved insufficient to protect privacy. And I guess my question is, why should we not simply then adopt here the same standards that are going to prevail in California, which are also consistent with the standards in Europe regarding minimization and consent and the general respect for consumers that those two sets of rules embody? I think that question lingers here. It will linger after this hearing. I recognize that your answers may be complex and lengthy, and therefore we don't really have the opportunity to explore all of those answers here. But I really hope that you will be at the table sincerely seeking to frame answers that protect American consumers. And so let me just open it to you to two final questions. Anybody here planning to pull out of Europe because of those privacy protections? Any of your company? No one. So you're living with them. No undue hardship. Any of you planning to pull out of California? Again, no one. No undue hardship. So what that tells me is that the opposition that you've expressed to these rules, recognizing that the devil may be in the details, is one that can nonetheless accommodate the kinds of rules that we have seen in the GDPR and in California, correct? Thank you, Mr. Chairman.
Thank you, Senator Blumenthal. Senator Markey.
Thank you, Mr. Chairman. The reason we're here is that Europe has now passed a privacy law, and that California has passed a privacy law. At the end of the day, the companies which are represented here today and all across the country are ultimately going to want California law preempted. And they're going to want other states' laws preempted. They're going to ask this panel to do that. So our goal has to be to ensure that any law which we pass out of this committee is a strong law. We don't need to pass weak laws in Washington that override strong laws in California or Massachusetts or other states. So that's why we're here. Because finally, Europe, finally, states are beginning to move in the absence of a federal policy. But that federal policy is going to have to be strong. The bill which I've introduced for years, which is essentially the Consent Act, basically says, one, people should have a right to knowledge that information is being gathered about them. Two, notice that that information might be reused for purposes that they never intended it to be used. And three, that they have a right to say no, that they don't want it to be reused. So, Mr. Kieran, I can begin with you. Would Twitter support a federal privacy bill that requires companies to tell consumers in a clear and concise way what information is being collected about them and how that information is being used, shared, retained, or sold?
Yes, Senator. Twitter already has those practices in place. We believe it's paramount to keeping the trust of the people that use our services, and we would support that type of legislation.
Would each of the other companies which are here support a provision which provides that level of information transparency with your consumers? Mr. Cowley?
Yes, no, we very much believe in transparency and giving customer choice. We do so today.
Mr. DeVore?
Yes, Senator.
Mr. Enright?
Yes, Senator.
Thank you. Mr. Tribble?
Yes.
And Ms. Welch?
Yes.
Okay, thank you. Of course, requiring transparency is a good first step, but we then have to move on to the question of the right of a consumer to say no, they don't want the information to be shared with anyone else other than the company with which they have been engaging in that relationship, that transaction. Mr. Enright, should a federal privacy policy establish consumers' right to control their personal information and give consumers the right to say no to their data being sold or shared with others?
Yes, Senator.
Yes. Mr. Cowley, do you agree?
Yes, I do, and I would like to just correct, I was informed, I may have misspoken earlier. Our policy very clearly says for the AT&T Communications Company, we do not sell personal information, and we reserve the right to share it, not sell it, with affirmative customer consent. So I want
I just want to keep going down the line on this question that Mr. Enright just answered. You agree with Mr. Enright? Mr. Cowley? Yes?
Yes.
Mr. DeVore?
Yes, Senator.
Mr. Kieran?
Yes, Senator.
Mr. Tribble?
Yes.
Ms. Welch?
Yes, Senator.
Ms. Welch, having control of information also means having access to it. Should Americans be able to access their personal data online? Would Charter support a federal policy bill that would enshrine that right into law?
Yes, Senator.
Mr. Cowley?
Qualified, yes.
Mr. DeVore?
Yes, Senator.
Mr. Enright?
Yes, Senator.
Thank you.
Yes,
Kieran?
Yes, Senator.
Mr. Tribble?
Yes, Senator.
Thank you. And Ms. Welch, thank you. Well, we have the beginnings of something here, although we'd have to come back to spend a little more time over here with Mr. Cowley and AT&T, which we're time limited. Just want to ask one quick question of Mr. DeVore. Recently, Amazon's facial scanning technology recognition misidentified 28 members of Congress, including me and Congressman John Lewis. I wrote a letter to Amazon about those issues. I don't think it quite answered all of my questions, but I just quickly ask you, can Amazon's facial recognition technology determine whether it is taking pictures of children under 13? And how does Amazon ensure that recognition, your product, is compliant with the Children Online Privacy Protection Act?
Thank you, Senator. To be really clear, that technology doesn't take any pictures at all. It's just a matching technology, and it depended entirely on the data set that a customer that's using the technology
uses in connection with the service. So it doesn't take pictures. It has a number of uses. It just matches photos and videos and objects, entirely dependent on the data set provided.
And the problem, of course, is that it matched me and Congressman Lewis and wound up putting me on a suspicious and into a suspicious category. And so have you tested it for any biases related to race or gender to ensure that that is not going to be a part of the product at the end of the day?
Senator, we have tested it. We are an innovation company. We're constantly improving the product. We have also replicated the study that the ACLU reported, and we're not able to replicate those results with a much, much larger data set. So we think there are flaws in the study. We've engaged with the ACLU to try to understand better what they did.
And I look forward to working with Amazon and all of you towards putting together a strong national privacy bill before we discuss preemption of state laws. Thank you. Thank you, Mr. Chairman.
Senator Markey, Senator Udall.
Thank you very much, Mr. Chairman, and appreciate the witnesses being here. And Senator Markey, I'm going to follow up on some of your COPPA questions there, since I know you were a big sponsor and passed COPPA in 1998, and I think it went into effect in 2000. This summer, I sent letters to Google, its subsidiary YouTube, MoPub, a subsidiary of Twitter, and Tapjoy, raising concerns about their compliance with the Children's Online Privacy Protection Act, known as COPPA. Mr. Chairman, I'd ask unanimous consent to add these letters to the record.
Without objection.
Thank you. Mr. Chairman, this committee needs to devote considerable resources and focus on policy to protect children's online privacy. We need to hold a separate hearing on what a future framework that protects children should look like. I mentioned Senator Markey's efforts on COPPA. The internet and our children's online activity look very different than when COPPA was passed. We didn't have Facebook or Twitter or social media. Our internet activity was not surreptitiously tracked. We couldn't imagine we would have speakers connected to the internet in our homes or in our kids' bedrooms. Our laws protecting children's privacy need to keep pace with the technology. Each one of your companies has said publicly or privately that we must push through federal legislation based on a framework that preempts states from passing their own protections. And I'm here to say we cannot push through a weak federal law that preempts states and leaves consumers, especially children, without the necessary safeguards and protections. We must have strong, enforceable laws, and we must continue our partnership with states' attorneys general, who I know from having served as New Mexico's attorney general, have their ear to the ground and receive a tremendous amount of input from consumers. Now, there are a number of public reports that strongly indicate that there are thousands of apps aimed at children that violate COPPA by tracking their online behavior. Do we all agree there is a potentially serious problem, that this is a potentially serious problem deserving of our collective attention? Yeah, yes or no down the line?
Yes, Senator.
No.
Yes, Senator.
Yes, Senator.
Yes, Senator.
Yes, Senator.
Thank you. Now, Mr. Enright and Mr. Tribble, Google and Apple dominate the mobile operating system. As such, they are tasked with ensuring that kid-directed apps on both platforms comply with COPPA. A recent New York Times analysis found that both platforms have apps in their respective children's or family sections that may potentially violate COPPA. What specific action does each of your companies take to verify compliance with COPPA in either the App Store or the Google Play Store, respectively? Mr. Enright, Mr. Tribble, please.
Thank you, Senator. And I'd like to thank you for your leadership in drawing attention to this important issue. Protecting children online is a top priority for Google. In connection with the App Store, we actually created the Design for Families program to help identify applications that are kid-directed. We require that third-party developers that submit applications to the App Store
identify whether in fact their applications are intended for children. And if so, they represent that they comply with the Children's Online Privacy Protection Act and other applicable legal requirements. If we become aware that they've violated those requirements, then they are removed from the Play Store.
Yeah, and do you agree that the studies and the reporting out there show that there are major violations of COPPA?
We rely upon the developers themselves to identify whether or not the content is child-directed. We think that the developers are in the best position to do so, rather than us as the platform operator. But we remain committed to doing all that we can to protect children when they're using our services.
Thank you for that answer. Mr. Tribble?
Yes, we are committed to protecting children when they use our service. And with respect to our App Store, we have very strict guidelines ourselves, consistent with COPPA, and we review every single app before it goes into the store. We review the apps before they get updated, and if we get credible information when an app is out there in the store that it has a problem, we will take action and remove it from the store.
Yeah. I just, in summary, and I thank you, Mr. Chairman, for the courtesies, just a second here. I think this is a very serious problem, and I think that any of you that would like, I'm out of time, but to answer the question or the issues that I've raised on the record, I'd appreciate that. But I hope, Chairman Thune, that we can look into this, because the record seems to be that there's a lot of violation of COPPA across the board, not necessarily just from these companies, but other subsidiaries and others that are operating out in this space. Thank you.
Thank you, Senator Udall, for raising that and keeping it in front of the committee's attention. Senator Gardner.
Thank you, Chairman Thune, and thanks to the witnesses for your time and testimony today. Mr. Tribble, on one hand, I was pleased to see a recent news article that highlighted Apple's decision to use the Taiwan's flag, and the name Taiwan in your latest product release last week. On the other hand, however, Apple has previously furthered China's anti-Taiwan propaganda, including through its software. For example, news reports revealed that Taiwan's flag emoji was not accessible for iOS users located in mainland China. This follows other instances of complying with Chinese demands, including removal of VPN apps on the App Store, forced data localization, and the potential for Chinese government access to sensitive personal information about dissidents and ethnic minorities. Does Apple consider the safeguarding of human rights or protection against government oppression when developing your software?
Thank you, Senator. We make our products for customers, not countries. And our values and beliefs, including privacy and security, don't change from country to country. And the privacy is one of our central values. And this is why we apply practices to protect our customers in China and throughout the world. We make sure...
I'm going to have to cut you short because I'm going to try to get through a lot here. Are those principles in the process for their consideration formalized in public?
Well, we have a major section of our website that goes through our privacy principles and examples of how we employ those principles.
Mr. DeVore, Amazon maintains operations in mainland China, albeit in a limited manner in accordance with Chinese law. Do you believe Amazon is operating under the same circumstances today that the company expected to operate under when you entered China several years ago?
No, Senator.
Has Amazon relinquished full control of its cloud-based assets in China in order to comply with recent changes to Chinese law? And as a result, does a particular Chinese company now have access to all related data Amazon previously stored and maintained on those assets in China?
Thank you, Senator. The answer to that question is also no.
To both those questions.
I'm sorry?
To both questions.
That's right.
Relinquished full control, answer is no.
That's right.
And no company in China has access to all related data Amazon previously stored and maintained on those assets in China.
Yeah, just to be very clear, so we're absolutely committed to security, particularly with regard to our cloud products. In order to operate in China, we are required by Chinese law to operate through a 100% owned Chinese subsidiary. And so it does function.
And that Chinese subsidiary does not have data Amazon previously stored and maintained on those assets in China?
Just very simply, the way the AWS services work is that they're for the customer. the entirety of the product service. So the customer gets an instance, and they have control over that instance and the data.
The Chinese company does.
No, the customers do.
Okay. So the Chinese company does not have any access to that data.
The way the system is built is designed to give customers absolute control over their data. That's structurally, that's the way it works there.
So the Chinese
As I mentioned, the
doesn't have
structure
that
of the
in-
business in China is different.
So we can talk about that further, but you're saying that the answer is no. The data Amazon previously stored is not in the hands of that 100% Chinese-owned company.
I'll try to be as clear as I can, Senator. The way that the system works is that data is actually controlled by the individual customers. That's the premise of the operation. The company is structured differently in China, and so we are operating in China through the subsidiary that I identified.
We'll continue that if we could outside of the hearing. Mr. Enright, Google made headlines in 2010 when the company made the decision to withdraw search engine services in China rather than comply with new Chinese censorship laws. Recent news reports, however, indicate that Google may be rethinking that decision. I understand you're unlikely to comment on those reports today, but you joined Google in 2011, shortly after that decision. In a 2015 speech at an International Association of Privacy Professionals event in Singapore, you said that the Asia-Pacific region was on the cusp of a tremendous opportunity to build a set of privacy laws and regulations that could foster, quote, economic, social, and public benefits that can be realized from data and data-driven technologies. Since you joined Google in 2011, and since that 2015 speech, do you believe that China's privacy laws and regulations have shifted in a direction that fosters such greater global engagement and economic opportunity?
Thank you, Senator. I have not seen legislative or regulatory developments in China that I think would fundamentally shift my assessment.
So the answer is no. The answer is no. Thank you. In that same speech, you said that your trips to places including Beijing and Shanghai, quote, established a commitment that me and my team would always remain closely engaged with our Asian colleagues to ensure that the evolution of Google's privacy program would remain sensitive to and informed by the perspectives from these important markets. Could you explain to the committee what you meant when you said that Google's privacy program would remain sensitive to perspectives from countries like China, who are major markets in the Asia-Pacific region?
Yes, Senator. Consistent with my prior remarks and with my remarks at the event you referenced in Singapore, and consistent with our values as an organization where right from our founding mission to organize the world's mission and make it universally accessible and useful, we design and launch products with an eye towards making the benefits of technology available as broadly around the world as we can. Expansion in APAC generally, in the Singapore market and in other areas where I was speaking, remains important. That said, as I had said earlier, I'm not aware of any plans that we are near to launching or close to launching a search product in China, nor do I think that we could or would launch a product without having our privacy controls thoroughly engaged, our privacy program actively involved, and any product that we launch anywhere in the world is going to reflect our values and the commitments that we've made to our users.
Mr. Enright, I'm very concerned about how people in China and other places where there are oppressive regimes will have access to technology that may change their lives, shift their lives when millions of people are imprisoned in political camps, internment camps, re-education centers because of their minority status or because of their religion. Churches are being bulldozed. I think it's very important that we have an open internet and that we continue that and that we use this great tool of freedom and democracy around the globe, and we have those values in U.S. Available to humans around the globe to provide and promote human dignity. Countries like China present major market opportunities for U.S. companies. I understand that. It's important to gain a foothold, boost revenue, and compete against other national companies, particularly those owned by China. But countries like China also have records littered with cracking down on dissidents, moving the goalposts for companies locating in their country, stifling free speech, and perpetrating human rights abuses against their own citizens. So American technology companies interested in growth abroad continue to find themselves in this very unenviable position of either having to defy local laws or having to provide hostile governments access to sensitive and personal information about their own citizens. Make no mistake, countries like China are already forcing companies, as we've heard today, to make these decisions. And as we've heard from
many of you on this panel. For decades, the U.S. has shown as a beacon of freedom and democracy, opportunity across the world. American companies help us carry that banner and those values to every corner of this globe. And I hope we can continue to work with all of you to discuss the challenges that we've covered today, to tackle these challenges and make sure that we get back to the day that our values carry the day as the world decides whether the path to prosperity runs through China or runs through the United States. Thank you, Mr.
Thank you, Senator Gardner. Senator Baldwin.
Thank you, Mr. Chairman. This has been a very informative hearing, and I hope the first of many to come. I would associate myself with the comments of other senators that we hear some additional perspectives in future hearings on data privacy, including consumer and privacy advocates, the states, and other types of entities. But thank you all for being here to testify today. Every day, Americans share enormous amounts of personal information with a broad array of companies, including hardware, software, and certainly retailers. And doing so has become just a central part of our everyday lives, and it provides tremendous benefits to us. But it has also become so commonplace that I think many do not fully understand what data that they may be sharing, and we've seen too many companies fail to keep that data secure or ensure that it's used for the purposes that their customers expect. I want to start, Mr. Tribble, after it was revealed that Cambridge Analytica obtained millions of Facebook users' data without their knowledge or permission, Apple's CEO, Tim Cook, suggested in the press that Facebook's business model, providing a free service supported by monetizing user data, carries different data privacy risks than that of a company that sells products or services to customers. I think there's a broad agreement that the same data privacy standards should apply to a range of actors in this sector, but as we look at the potential federal legislation around data privacy, how should we take into account incentives around treatment of user data that may or may not exist depending on the business model?
Thank you, Senator. Well, Apple's business does not depend on collecting customers' information. It's not our lifeblood. Nonetheless, I believe that any comprehensive legislation should apply equally to companies because, almost any company in operation today is going to at some point touch customer private information or personal information. So I think there should be a even playing field. Everyone should be subject to comprehensive federal regulation in that respect.
And Mr. Enright, what is, as a company that also offers free services to consumers, what's Google's perspective?
Thank you, Senator. I think it's important to point out that Google's business model is predicated on the trust of our users. If our users don't trust us with their data, our long-term success is in peril. I would also point out that many companies, both those testifying here today and elsewhere, rely upon things like ads and search for their business models to work as well. And I think it's encouraging to hear from the testimony today that there seem to be shared values of choice, transparency, and control. And I agree that if we can begin from those first principles, continue the discussion looking at inputs like the legislative framework that we recently published, we should be able to find a sort of a shared understanding and a shared direction for uniform legislation to protect consumers.
I'm hoping to fit in two additional questions here. In terms of commitment to transparency about what you do with the data of your customers, I want to clarify whether any of you would distinguish between data that a consumer knows they give you or data that she may not know that she is providing. For example, websites she visits or her location. Does anyone distinguish between those? Mr. Kelly?
I don't believe so, if I understand the question. We treat information, if it's personally identifiable or not, and personally identifiable nature. Information includes information a customer gives us, or information we observe. It can. So there's no distinction in that regard.
Okay. Mr. DeVore?
Senator, we endeavor to take great care of customers' information no matter what. And we really think about it not in terms of data, but in terms of customers and trying to delight customers with our products and services in a way that they understand how their data is being used, that provides great value to them, and in best case, delights them with the way the products and services work. Different data, I think, should be protected more when it's more sensitive or when it's used in a sensitive way. And that's the way we think about protecting customer trust in connection with everything we do.
So you do make those distinctions, it sounds like. Mr. Enright?
Consistent with the general principles of choice, transparency, control that we've described, while I do recognize that the way that we treat consumer information should be proportional to the level of risk associated with that information. I think more generally, in response to your specific question, we should recognize that there is an obligation across industries to invest heavily in consumer education and consumer awareness so that users really do understand the kinds of information collection and use that is involved with the various services within which they're engaging, and similarly invest in improved controls and awareness of those controls so that we put users back in the driver's seat and they remain in control of how companies are using information from and about them.
Mr. Kieran?
Senator, we don't differentiate between the data. We largely have sort of 3 blocks of data that we receive at Twitter. So there's sort of the public data that we would receive from you when you use our service. So whether it's a tweet or a retweet or a favorite or a like. There's the information that we need when we are operating the service. So that might be things like your IP address to serve it to you in the right language, and other information that we might get about your device. And then there's the third bucket, which is sort of the consent-based, where it's information that if you want us to customize the service to your likings, we'll get your consent for it. But we're very transparent in those types, in those individual buckets. We provide users the ability to both see it through a dashboard, but also to download a copy of it. But we do treat it all in a similar fashion in terms of transparency and control.
We go through great efforts to explain to customers how we're collecting and using their data, but we don't differentiate data based on whether they understand that or whether they know that the data is being collected at the end of the day.
Senator, we also focus on the personal information of the customer and make sure that we're protecting that. And we believe any future framework should likewise empower the consumer to really have an affirmative choice about how their data is used.
Mr. Chairman, I know I've run out of time. I just want to put a question out there for the record, and I'll follow up with the witnesses later. But just sometimes it's hard for me to figure out if we are talking about data security or data privacy or both. And this hearing is focused on data privacy, but I'm wondering if our witnesses think we have an adequate way of drawing a line that distinguishes between the two. When I think about, I have expectations of both security of my data as well as privacy, and sometimes that is a very gray area.
Yeah, they get used interchangeably. No. Well, that's a good question for the record.
Well,
we'll look forward to having.
Yeah, I mean, there's a difference between a hack and a breach.
Yeah.
And sale of it, but there's expectations that the Congress of the United States might act on both. Should we do so in one bill, or 2 bills, or multiple? Anyways, it creates a lot of interesting additional dialogue that we don't have time for at this moment.
We've been trying to solve the data security issue for a long time, so far without success. So maybe coupling it with data privacy will get us that. We'll see, but these hearings are helpful in that regard. Senator Cruz, you're up.
Thank you, Mr. Chairman. Welcome to the witnesses. Mr. Enright, I want to go back to the topic that a couple of other senators raised with you, which is China. after a cyber attack compromised the Gmail accounts of dozens of Chinese human rights advocates. Google decided in March of 2010 to shut down its operations in China. At the time, Google released a statement that said, quote, "We want as many people in the world as possible to have access to our services, including users in mainland China." Yet the Chinese government has been crystal clear throughout our discussions that self-censorship is a non-negotiable legal requirement. Despite taking this principled stand in 2010, it's been reported last month that Google has been secretly developing a search engine for China as part of a project known as Dragonfly. Are those reports accurate?
Senator, thank you for the question. As we've said, I'm aware of those reports. I need to be clear for the record that my understanding is that we are not close to launching a search product in China, and whether we eventually could or would remains unclear.
Is there a Project Dragonfly, and if there is, what is it?
We have an array of internal projects, and I wouldn't think that it was necessarily appropriate for a privacy conversation to speculate as to what we might be looking at in terms of a product launch in some part of the world.
So you're not answering my question then on Project Dragonfly?
There is a Project Dragonfly.
And it's focused on a search engine in China, is that accurate?
There is no, we are not close to launching a search product.
You're saying you're not close to launching. I'm asking, is the topic of Project Dragonfly, is it a project to develop a search engine in China? I didn't ask timing of launch. I asked what it is.
Understood. I am not clear on the contours of what is in scope or out of scope for that project, but I can say that if we were close to launching a search product in China, myself and my team would be very actively engaged to ensure that it was going through the appropriate privacy review process and that it was consistent with our privacy values and the commitments that we've made to our users.
In your opinion, does China engage in censoring its citizens?
As the privacy representative for Google, I'm not sure that I've had I'm not sure that I have an informed opinion on that question.
It's also been reported that more than 3,100 Google employees sent a letter to Google's CEO earlier this year protesting the company's work on Project Maven, a Pentagon pilot program aimed at speeding up the Defense Department's use of artificial intelligence technologies. Likewise, 1,400 Google employees signed a letter last month protesting Google's plans to create a censored search engine for China. Mr. Enright, you've worked for Google since 2011. Does it concern you that more than twice as many employees at Google have protested working with the U.S. military than have protested creating a censored search engine for China?
Senator, I take a great deal of pride in the fact that Google is an organization that allows employees to voice their opinions, including opinions about product strategy, product decisions, right up to the senior-most leadership of the organization. As to Project Maven, again, my understanding is that there was internal concern raised. Employees were given a voice. There was a significant internal discussion around the project. It ultimately affected the strategic direction of leadership. And while Google continues to commit to meeting the responsibilities of our initial Maven contract, and we're continued to work with the United States government, the Department of Defense in certain areas, including cybersecurity, healthcare, and productivity. But we are focusing on making sure that our collaborations with the government are consistent with our core values.
Let me try again, because your answer didn't answer my question. Does it concern you that more than twice as many Google employees expressed concern about working with the U.S. military as did concern about being complicit in China censoring its citizens?
It encourages me that Google is a place where employees are able to voice those kinds of concerns about projects that they want to ensure are consistent with our values.
Do Google search results as a systemic matter tend to favor one political party over another?
No, sir. We build products for everyone. And in my experience, I see no evidence of bias in the way that our products and services operate.
Okay, so you gave a categorical answer, no, they don't favor one party over the other. What is the basis for that answer? Upon what data do you rely?
The basis for that answer, Senator, is my own experience and my own understanding of our products. I have not reviewed data, so I'm...
Does Google assess whether its search results are biased in favor of one political party or another?
My understanding, again, as a privacy executive for Google, so we're stepping outside of my core domain here, but my understanding is that one of the paramount design decisions for our engineering teams in our many products is that we are designing for everyone.
Okay, Mr. Enright, we're having a problem with answering the question. I asked if Google assesses this question. If you studied, I can tell you millions of Americans, I can tell you millions of Texans believe that big tech companies are actively censoring the speech of American citizens and are silencing the voices of conservatives. One of the frustrating things about this issue is there's almost no transparency. There are almost no public data to assess if that's accurate or not. So my question is Google analyzing the question? Is Google actually looking, not your own personal experiences searching, but are you assessing it empirically? Upon what data do you make testimony in this committee that Google is not favoring in its search results one party over another or one candidate over another?
As the Chief Privacy Officer of Google, this is not within my core domain, so I can only speak to my own experience and the things that are my responsibilities within the organization. But within my purview, I have never seen any evidence of bias, and I consistently see a commitment.
Okay, I'm going to try just one more time. Are you aware of any efforts of Google to assess whether search results have a political bias? Don't give me a statement they don't have a bias. Are you aware of efforts to actually empirically assess and determine it?
As Chief Privacy Officer of Google, I am not aware of such efforts.
Thank you.
Thank you, Senator Cruz. Well, I think that kind of wraps up our hearing. I'm going to ask unanimous consent to include in the record letters from the Association of National Advertisers, the Interactive Advertising Bureau, the Internet Association, the National Association of Federally Insured Credit Unions, Privacy for Cars, and the U.S. Chamber of Commerce. Without objection, we will keep the hearing record open for a couple of weeks and ask senators who have questions that they want to submit for the record to get those in. And then as you receive those, if you could, as quickly as possible, submit your written answers, but no later than October the 24th, Wednesday. We'll continue to pursue this issue, and as I mentioned, this will be the first of what I suspect will be other efforts to get input from those who are affected by the privacy issue and have an interest in seeing Congress move forward in a way that is consistent with what we think are many of the principles that you have outlined today, but certainly giving consumers the choices and opportunity to meaningfully consent, make sure there's transparency in the policies that you all employ, knowing full well that there are other models out there in Europe and California, and much of the testimony today obviously dealt with the need to have a consistent, uniform policy that can be applied to everyone across the board. And interesting to hear the comments with respect to tech companies and ISPs today as well. So we appreciate your testimony, your responses to our questions. I think it's been very informative, and it will help shape what we do going forward. I think there were a lot of important questions asked today, and some answers I think will, as I said, be very helpful in our deliberations moving forward. So thank you all for being here, for your willingness to testify, and we'll look forward to continuing to have this conversation. And I'm certain it won't be the first, but probably one of many conversations going forward. With that, this hearing is adjourned. Number of members on this committee and other committees that have an interest in this issue, and so we're looking at what's out there, and obviously studying some of the things that have been done other places. I've got a lot of input today on GDPR, and we think there is a way of doing this that sort of meets the priorities that we have and the consumers and stakeholders are going to have, but also, does it in a way that we think protects, not only protects the users and consumers out there, but also I think protects the startup companies that, obviously could be impacted by cost of compliance if it's an overly burdensome regulatory regime.
Senator, on timing, I mean, you mentioned this is a complicated issue. Obviously, we have an election coming up. I think there's some question about whether you'll still be helming the committee next cycle. I mean, what do you expect to see going into next year if leadership's different? If the same folks aren't going to be taking a stab at this come January?
Well, I think anything that comes out of this committee, or any product of its collective work of any number of committees, as you know, in the Senate, it's going to have to be bipartisan. So whoever's in charge after this election is, I think this issue's not going away, but I think it's going to have to be a bipartisan solution. So like we usually do on this committee, we work with both sides and try and make the best ideas.
And the Democrats are skeptical. There were several senators who expressed skepticism that the industry seems so open now to a bill after California saying they want to make sure it's a strong bill.
Yeah.
Well, I mean, what's your reaction to that? Is it going to be a strong bill, or do you think it's going to be something industries can feel is sort of window dressing that they're happy with?
Well, no, I mean, I think that industry wants, a uniform, consistent standard. They want preemption, and they want a national approach to this, not a 50-state approach. So I think that provides us with some leverage, and I think it also suggests that they're going to have to be at the table and offering up good solutions for this. But we'll see what happens. Like I said, we'll hear from some of the consumer groups later, and we're going to try and incorporate the best ideas. But I think what you heard today were several themes. One is they like the FTC as the regulator. They want to, they obviously want preemption. They want a national approach, and they want an approach that I think consistently applies to all the players out there in the space. So those are all good. Those are good things to know going forward. And obviously, as we look at what we might do legislatively, it will have to incorporate, again, Democrat ideas as well. Now, they'll probably generally want a more heavy regulatory approach at the federal level, and we'll be pushing hard in that direction. We always, of course, over here sort of prefer a light touch approach. And so I think anything that we come up with is, we'll have to incorporate, again, ideas from both sides. But my hope in the end is something that creates a regulatory framework that provides the privacy protections that we think consumers deserve, but does it in a way that doesn't impair the business models of a lot of these companies who have been very, very successful and provided tremendous opportunities for consumers around the country.
Senator, in your exchange with Senator Baldwin, you suggested that there might be a potential to include a security component in the privacy bill. Can you tell us what you were thinking about when you said that?
Well, I just think, I don't know that can happen. We've been negotiating a data security solution for years, basically. haven't been able to get everybody on the same page. These are sort of separate issues. They do get, they do get sort of morphed together at times. But I think that the privacy legislation, if you were going to put together some bills and there were equities that different players or stakeholders had that might bring them all to the table, if that could happen, that'd be great. If we could get them both done. But that remains to be seen.
And we have to get across to the next meeting.
Any plans for any startup now that's not included in the FAA reauthorization?
Well, we'd love to get it done, and we're still looking for a vehicle that can ride on, legislative vehicle, no pun intended. But I think it's all going to come down to whether or not we can negotiate and get agreement. Right now, basically, it's between the trial lawyers. It has to do with some of the preemption and liability issues. And if we can reach an agreement there, I think there's a good chance it could move this year.
Thanks. Thank you all.
Okay, right here.
Really fast. Yeah.
Robert?
Saturday, 2 retiring members of Congress, Republican Congressman Bill Schuster of Pennsylvania and Democratic Congressman Luis Gutierrez of Illinois, talk about their experience in Congress.
I'm coming to the end of my term as the chairman of the Transportation Infrastructure Committee, which Republicans term limit ourselves in our leadership positions. And that was really the driving force. I kind of thought to myself, playing sports throughout my days in high school, when you're on the starting team and they put you on the bench, it's really not too much fun. So I decided that it was time for me to leave and make room for new members. We got a lot of great people on the committee, and I don't have any doubt that someone will replace me and they'll continue to do good work.
I've been here 26 years in the Congress of the United States. I believe, and I think the last couple of weeks are demonstrative of that, that I've helped create an immigrant movement in the United States of America. And in the Democratic caucus, in the Democratic Party, and in many areas and spaces, economic, business spaces, right, educational spaces, but most importantly in this political space that is the Congress of the United States, a genuine support and majority for immigration reform.
Join us for our conversations with Congressman Bill Schuster and Congressman Luis Gutierrez, Saturday at 10 p.m. Eastern on C-SPAN and cspan.org, and listen on the free C-SPAN radio app.
There's every president, I think, would confirm that experience. For I'm going to tell this guy off, I'll get him, and then they go in there, and there's something about the office itself and the respect that most foreigners have for that office, where you just don't feel like bawling out the president or taking him on the way you told your colleagues you were going to do.
You know, when he was in China, he was eventually called back in order to run the CIA. Something he didn't want to do because he thought, to be honest, running the CIA was a political career killer. He still had aspiration for higher office. And then he says, and I think we should take him at his word, that he remembered his father saying, if the President of the United States asks you to do something for your country, the answer is yes. That sentiment, I think, really embodies his entire sense of obligation, not to necessarily be a president in his own right, but to hold the presidency up as a charge to hand off to the next person.
Jeffrey Engel, director of Southern Methodist University's Center for Presidential History, discusses his book, When the World Seemed New, President George H.W. Bush and the End of the Cold War, Sunday night at 8 Eastern on C-SPAN's Q&A.
At a Senate hearing on automobile tariffs, auto industry executives and labor union leaders talked about the effect that new tariffs could have on their industry and manufacturing jobs. Witnesses also talked about U.S.-China trade relations, NAFTA, and tariffs on steel and aluminum. Senator Orrin Hatch chairs this 2-hour Finance Committee hearing.
The committee will come to order. I want to say good morning and welcome everyone of you here today to this hearing on the impact of tariffs on the U.S. auto industry. In particular, I'd like to welcome our witnesses and thank them for joining us today. I intend to focus this morning on the investigation that was self-initiated by the Department of Commerce under Section 232 of the Trade Expansion Act of 1962 to determine whether imports of automobiles and automotive parts threaten to impair our national security. Many of us on the committee have already expressed our concerns about the administration's heavy reliance on tariffs. In June, Secretary Ross appeared before this committee to explain the department's finding that steel and aluminum imports threaten to impair our national security. As a result of that determination, the United States is currently imposing tariffs of 25% on steel products and 10% on aluminum products. Combined, these tariffs directly affect almost $50 billion worth of goods, while also affecting many billions of dollars more in downstream goods. These tariffs cause American manufacturers and farmers to pay more to conduct business and consumers to pay more to buy these things. One industry that has been harmed by the steel and aluminum tariffs is here before us today, the auto industry. The American Automotive Policy Council estimates steel and aluminum tariffs will cause a $400 per car increase. Auto suppliers and consumers are already suffering from Section 232 tariffs. That's one reason I was stunned